Hello everyone, this is a video presentation for our international law subject, and today we will be introducing to you the Law of Treaties. There are 6 main topics that we are going to cover today: definition of a treaty, the Vienna Convention of Treaties, also known as VCLT, the process of treaty making, the interpretation of treaties, invalidity of treaties, and lastly, the termination of treaties. The definition of a treaty. According to the Oxford Dictionary, a treaty is a formally concluded and ratified agreement between countries. Treaties form the basis of most parts of modern international law. They serve to satisfy a fundamental need of states to regulate by consent issues of common concern, and thus to bring stability into their mutual relations. Treaties are also known as convention, pact, agreement, and more, as an instrument for ensuring stability, reliability, and order in international relations. Treaties are one of the most important elements of international peace and security. This is why from the earliest day in the history of international law, treaties have always been the primary source of legal relations between entities, today known as states. Here's an example. The agreements between Christian rulers and states became more and more detailed until the Peace of Westphalia, concluded in 1648 in the cities of Münster and Osnabrück, undertook the first attempt of building a common European order of peace. Topic 2. The Vienna Convention of Law of Treaties. The VCLT of 1969, also known as the Treaty on Treaties, established comprehensive rules, procedures, and guidelines for how treaties are defined, drafted, amended, interpreted, and generally operated. The VCLT is considered a codification of customary international law and state practice concerning treaties. The VCLT of 1969 applies only to treaties between states, instead of treaties between subjects of international law, and only to written instruments, instead of all forms of agreements. The VCLT of 1986 applies to only treaties between states and international organizations, as well as treaties between international organizations, and only to written instruments. The treaty-making process consists of identification of needs and goals, negotiation, adoption and signature, and ratification. For treaties regarding environmental issue, the treaty itself has to be backed up by science and data. For example, the Vienna Convention for the Protection of the Ozone Layer was backed up by the research of multiple scientists in the 1970s, which discovered the fact that chlorine released into the stratosphere can damage our ozone molecules. Step 2 is negotiation. There can be bilateral negotiation, where a state often simply asks another state, and there's also multilateral negotiation, where individual states may negotiate, or state will recommend that international organization to establish a committee or hold an international conference. First, preparatory committees, working groups, symposia, preliminary conferences will be held, and then comments from NGOs, scientific unions will be accepted. After that, the plenipotentiaries will be convened, and finally, the final version of the treaty, the authentic text, will be drafted. Step 3 is adoption. The text must be adopted at the end of the negotiation phase in order to open the treaty for signature and ratification. Adoption is governed by the Article 9 of VCLT. At an international conference, 2/3 of the present and voting need to vote to adopt, unless other methods are agreed upon by the same majority. Adoption does not bind, but merely means participants find the text acceptable. The final act incorporates the history of the treaty. The treaty text is incorporated into or annexed into the act. If negotiations occurred within international organizations like the UN, a resolution must be passed to approve the text. The treaty must be authenticated. Authentication is governed by the Article 10 of the VCLT. Authentication is generally done by signature, although this does not bind the state. Under Article 18 of Vienna Convention, however, a state may not do anything that would defeat object and intent of the treaty. Step 4. Ratification or accession. A state can only be bound if it expresses the will to be bound. Various methods are given under Article 11 of VCLT. Ratification. Only states that negotiated and signed the treaty may ratify it. It is the most common method for multilateral agreements. In our textbook, ratification is defined as any authoritative act whereby a state declares to the international community itself to be bound by a treaty. Domestic political requirements often must be met before ratification. For example, the U.S. Senate has still ratified the International Criminal Court. The United States cannot ratify the ICC until the U.S. Senate ratifies it. Accession. Non-signatories may join by accession. State declares intent to be bound by the treaty. The methods are often specified in treaty. Limited consent and reservations. A state can limit its consent to only a portion of the treaty if the treaty permits it, or if other states agree. If limited consent is unavailable, the state can still enter objections and reservations at the time it gives consent to be bound, as long as it's not prohibited by the treaty or contrary to the object or intent of the treaty. Legal effect of reservation depends on whether other states accept the reservation. A reservation can affect bargain for rights, threaten ratification, and complicate the application of the treaty. Therefore, many modern treaties prohibit reservations. Entry into force. Parties become bound by the treaty when it enters into force. A treaty enters into force after it has been ratified under national law, and the state deposits its instrument of ratification, and if the treaty has no other specifications, all negotiating states have ratified. Often, a minimum number of states must ratify the treaty for it to enter into force. Topic 5. Invalidity of Treaties. The following 5 scenarios can cause a treaty to become invalid. First, violation of international law on competence to conclude treaties. Second, error. Third, corruption. Fourth, coercion of a state. Fifth, conflict with jus cogens. Topic 6. Termination of treaties. The termination of a treaty can be done on internal grounds. According to Article 54 of VCLT, the termination of a treaty or the withdrawal of a party may take place in conformity with the provisions of the treaty, or at any time by consent of all parties after consultation with other parties. The termination of a treaty can also be done on external ground, through material breach. In Article 60 of VCLT, material breach is defined as repudiation of the treaty not sanctioned by present convention or the violation of a provision essential to the accomplishment of the purpose of the treaty. Supervening impossibility of performance. In Article 61 of Vienna Convention, this ground was limited to the permanent disappearance or destruction of an object indispensable for the execution of the treaty. Fundamental change of circumstances. This only applies to the most exceptional circumstances. Or otherwise, it could be used as an excuse to evade all sorts of inconvenient treaty obligations. That's it from us. Thank you for watching.